In Chapter 3 of Criminal Law, we're going to be talking about essential elements of a crime. This is very important to everything that we're going to do in this course, so pay attention. Each element of the crime must be proven beyond a reasonable doubt to convict someone of a criminal offense. This is the general rule that exists for nearly every element of the crime. Beyond a reasonable doubt means that it is not enough to prove that it is probable that an element of the crime is true. The proof must be such that a reasonable person would agree that the elements of a crime are present. For civil offenses, the elements to be proven are beyond the preponderance of the evidence. Beyond the preponderance of the evidence means more likely than not. In other words, 50% plus a feather. The elements of a typical criminal offense include the actual act, the mental intent, and the knowledge of wrongdoing. Those are defined as the actus reus, which is the criminal act or the actual act, the mens rea, which is the criminal intent or the intent, and then the scienter, which is the knowledge of wrongdoing. The requirement that the mental intent and prohibited act must both be present in crimes requiring mental fault is called concurrence. So in other words, the actus reus and the mens rea must occur at the same time. Thoughts by themselves are not crimes, and pure accident is not a crime. The forbidden act, or the actus reus, the crime is an intentional act or omission of an act. An act has to occur for there to be a crime. There are different acts for different parties to crime. So a party to a crime could be a person who actually or physically commits the crime, a person who conspires in the planning of the crime or orders that the crime be committed, or a person who aids and assists the commission of the crime either before or afterwards. In some situations, failure to act can constitute a criminal offense, and we'll talk about those in just a second. Failure to act crimes. So this is a very small percentage of crimes in the criminal code which have an act of omission as a essential element of the crime. Failure to act when duty or obligation is imposed. And some of the examples of this include the failure to report the death of a child, the failure to report the location of a human corpse, failure by a parent or guardian to provide adequate food, clothing, shelter, or medical care to a child under the person's care, and failure of one involved in an accident to remain at the scene, so leaving the scene of an accident. In most criminal codes, the actus reus, the criminal act, must be accompanied by the mens rea, or the criminal intent. There are degrees of mens rea, and those are generally purposely, knowingly, recklessly, and negligently. You may see intentionally in there. There's a couple of others that you'll see in different states. But the Supreme Court has not held that mens rea be proven. But if it's required by a state, it must be proven beyond a reasonable doubt. There are two basic types of mens rea, the specific intent and general intent. Specific intent, the party intends for the desired result to occur, links the mental state or purpose to the forbidden act. So you must prove the mental fault for different parties to a crime. The general intent, the party did not intend for the specific result to occur, but should have known better. No requirement for intended result, no longer stressed in classifications of crime. So if you went back to the previous screen, you would see that knowingly and purposely would be specific intent, and the other two would come under general intent. The exception to mens rea, the Supreme Court has never created or announced a doctrine requiring proof of mens rea in all crimes and in all cases. The states are generally free to create criminal laws that do not require proof of mens rea or to create criminal laws requiring different degrees of mental fault or mental guilt. So some of the examples of the exception to mens rea include felony murder doctrine, strict liability crimes, and then possession alone as a crime. So the felony murder doctrine does not require that the person have the intent to kill anyone. It just means that during the commission of a felony, a person was killed. Strict liability crimes we'll talk about in just a minute, and then possession alone we'll also talk about. So the scienter, the knowledge. This is a word that sometimes hangs students up. It's nothing to worry about, though. So if a statute requires knowledge about the existence of a fact, that knowledge must be proved by the prosecution. So it becomes a third element of the crime that needs to be proven by the prosecution. Some of the examples which state statutes require a scienter: in assault of a law enforcement officer, the knowledge that the victim is a law enforcement officer can be a scienter in that case. In refusing to aid a law enforcement officer, knowledge that the person requesting the assistance is a law enforcement officer is an element of that crime. In receiving stolen property, the knowledge that the property received is stolen property. That isn't the case in all states, but if it is required that the knowledge be there, if that scienter, the knowledge of the property being stolen, is part of the criminal code in that state, then that is one of the elements of the crime. In harboring or aiding a felon, knowledge that the person aided is a felon is usually required. So that would be a required element of the crime of aiding and abetting. So these are two words that trip up students frequently. Mens rea is the intent. Motive are sometimes thought of as being the same thing, but they are two distinct things. The intent is the mental purpose or design to commit a specific act or omission to commit an act, usually an element of the crime. Motive is the cause, the inducement, or the reason why an act is committed. So the motive goes to why the person committed the crime. The intent was the mental intent that the person had when committing that crime. And though the intent is the element of the law, motive is usually not an intent of law. Motive is usually not an element of the crime. Strict liability crimes. These types of crimes also do not require any proof of mens rea. So some examples are traffic laws, laws on liquor sales, laws on purity of food, hunting laws, laws on protecting children, and laws on narcotics offenses. So what that means is that if you get stopped for going 65 miles an hour in a 40 mile an hour zone, they do not have to prove that you knew that it was a 40 mile an hour zone. They don't have to prove that you had that intent to commit that crime. All they have to prove is that you were going over the speed limit at the time of the offense. Now, that doesn't carry in all states. I worked in the state of New Hampshire, and in the state of New Hampshire, traffic law, the speeding signs are just a suggestion. What the state has to prove in that case is that your speed was unreasonable for the conditions that existed at that time. But generally, traffic laws in most states are an element of the crime, the mens rea. So the year and a day murder rule, this is generally a rule that some states follow. Some states have 3 years and a day. Others have abolished this altogether. What it says is that the death of the victim of a murder, if it occurs within a year and a day of the criminal act, the actual shooting or killing or the attempted killing, In order to be it to be the cause of the death, it has to occur within a year and a day. But because of changes in medical science, perhaps most states, either by statute or court decision, have abandoned the year and a day rule. There are still some on the books. The case of Rogers v. Tennessee in 2001, this was a U.S. Supreme Court, and they held that retroactive application of judicial changes in the law violate due process only when they are unexpected or indefensible. It held that retroactive abolition of the year and a day rule by the Tennessee Supreme Court did not violate due process because the rule was not a well-recognized rule in Tennessee. Possession alone is a crime. So all states make the possession of certain objects a criminal offense. Types of possession are actual and constructive. So possession is one of the rights of ownership, but ownership does not need to be proven in criminal statutes. So in other words, if you are, let's say that the police come in with a warrant and there's 5 people sitting around a table with lines of cocaine on the table. The state does not have to prove that you owned that cocaine. It also doesn't have to prove that that the cocaine was actually yours. All they have to prove in that case is that you had constructive possession. In other words, you had the ability to use that cocaine that was there. And what the courts have said generally is that if you are within arm's reach of that drug or illegal contraband, whatever it is, that is in your constructive possession. Hope you've enjoyed the video. You can find me at www.stevedyer.com, and that will bring you to my Today's News in Criminal Justice website. It's a website of news in criminal justice for that day that I curate throughout the day, and that is available online at any time. It populates at 8 o'clock in the morning, and then throughout the day I edit it and put new stories in. And then that picture at the bottom is my beautiful place of work, Thomas College, which I absolutely love and adore. So thank you for watching the video. If you liked it, hit like, and if you'd like to subscribe, please hit the subscribe button. Thanks a lot, and we'll see you later.